Hi, and welcome to this webinar for local authorities and the public sector. I am Kirsty Porter, and my colleague is Kate, who you can also see on the screen. We are both associates with Burkitt Solicitors, who are, oh sorry, there you go. We have the lovely Natalie helping with our screens today, so she will be moving them across for us. So if we shout out to move on, then that's why. So yes, Kate and I are associates with Burkitt's. My background is in the public sector. I was formerly a data protection officer at a local council, and Kate's background is within the insurance sector. She was a commercial lawyer in the private sector, but she's been at Burkitt's a few years now. And we both sit within the commercial and technology team at Burkitt's, but we are both solely dedicated to data protection, so we deal with this day in, day out. You will see from the next slide a little bit about Burkitt's. So we're quite a large organisation now. We've grown substantially over the last few years. We've expanded into Sevenoaks and London, and we have you'll see over 1,000 people working and over 500 lawyers. So a little bit about the course. We have tried to aim this at a intermediate advanced level. We understand that you're all lawyers, so you have a good understanding of the basics. If we do cover something that you're not too sure on, please just pop a question in the chat and we will try to pick that up. The plan is to answer any queries at the end, but if there's something pressing which doesn't sort of make sense, or you have something to pick up on as we're going through, please pop a message and we will try to get them. As there's two of us, we'll try to do that while the other one's speaking. So we've allowed 18 minutes for today with a short Q&A at the end. That's the idea. So an hour and a half, and we will hopefully cover this between us satisfactorily. So over to Kate to start with part one.
Hello, everybody. You always get that tickle in your throat just about to start speaking. I do apologise, I was waiting for it. So part one, as you can see on the screen, practical tips and techniques to tackle everyday issues with data protection. If I could have the next slide, please. Now, as Kirsty said, we appreciate that you all know what you're doing, for want of a better expression. But to keep things clear in your mind, it always helps to strip it back to basics. So before we get into the substance of this part, we're just going to look at some of the key elements of data protection law. So first of all, where do we find it? So we retained the EU GDPR, which we call the UK GDPR, made some changes to it post-Brexit. And in 2018, when the European GDPR came into force, we brought the Data Protection Act 2018 into force to supplement the UK GDPR and take account of any derogations that we might have achieved from that. We've put here the Privacy and Electronic Communications Regulations, mostly known as PECR. That's not hugely relevant to the public sector, apart from where you potentially use cookies on a website, but we've put it in here as it's obviously a key part of the legislation. And on the horizon, coming ever closer because it's kept being put back for time after time after time, we have the Data Protection and Digital Information Bill, which is expected to be passed later this year, and that will amend the UK GDPR, the Data Protection Act, and PECR. If I could have the next slide, please. So now we know where the law is. I find the best way to look at this is to boil the law down to one sentence. And if you could describe data protection law in one sentence, it would be, you must only process personal data in accordance with the data protection principles and in a way which respects individual rights. So we're going to look at some key elements of that sentence. The first one being what the data protection principles are, which I'm not going to go through in detail because I am aware that you will know what they are, but there are 6 of them. They are set out on the screen. They're found in Article 5 of the UK GDPR. And in essence, Article 28, sorry, should know that, Article 25 of the UK GDPR talks of the concept of data protection by design and default, and everything that you do with personal data, any ideas you have, your systems, your processes, your software, your storage, should from the outset be put into force in consideration of these 6 principles, and you will be well on the way of meeting that requirement. Next slide, please, Natalie. Thank you. But we also have what we call the unofficial 7th principle, which can quite easily be forgotten about, but it's probably one of the most important things for everybody in this virtual room. And that is what we call the accountability principle. And this is Article 6. You must be able to demonstrate how you comply with the 6 principles. And we have put on here certain indicators of an accountable organisation. Some of these are going to be mandated by data protection law, such as having a privacy policy for you to put your Article 13 information out, transparency information out to data subjects. Things like records of processing activity and potentially appropriate policy documents where you are processing special categories of data or criminal offence and convictions data, which we would imagine that in most cases you probably will, even simply to the extent that you employ people. And some of them are simply best practice, such as data protection policies, information security policies. So we've got a list of them here, and I would expect that you already have the majority, if not all of these in place. And a key one being a clear governance structure. As public authorities, you're going to have a DPO because the law requires you to have one, but you will also have several individuals within the organisation who have a clear understanding of data protection law and how it applies in the particular area that they're working in, and they can liaise with the DPO to ensure that you're compliant at all times. Moving on. Thank you. We've covered the principles, so we'll have a look at personal data. And we know that personal data is information that relates to an identified or identifiable natural person. Currently, the law doesn't say anything more than that, and our guidance for, or our authority for when somebody is identified or identifiable is actually set out in ICO guidance. And the principle is that if you can identify somebody just from the bit of information that you're looking at, they are directly identified. If you can identify them from that information, but you also need other information that might be available to you, then they are indirectly identifiable. Now, the Data Protection and Digital Information Bill, or DPDI, as we're going to call it for ease, for the purpose of this webinar, is actually going to incorporate this guidance or this clarification into the law by amending Section 3 of the Data Protection Act when that comes into force. And on the next slide, we'll be able to see the wording that they propose, or is proposed, in terms of when an individual might be indirectly identifiable. So a living individual is indirectly identifiable, it will say, where the controller knows or ought reasonably to know that A, another person will or is likely to obtain the information as a result of the processing, and B, the living individual will be or is likely to be identifiable by that person by reasonable means at the time of the processing. So that does actually serve to narrow the scope a bit by not necessarily having to think about how likely it is that certain information might be publicly available or available to somebody not adhering to your data protection policies. But as always, whenever we've got the words reasonably in any bit of statute, this is going to need to be tested, and that's either going to be in case law going forward, or ideally by ICO guidance before any of that has to happen. So which comes first? I think we've skipped, thank you, we skipped a couple of slides there. So the key areas we're going to focus on for practical tips and techniques for everyday issues with data protection. We're going to have a look at handling subject access requests and different peculiarities in terms of freedom of information and environmental information regulations and requests for information there. Managing data breaches and some content about contracts, all of which we find to be common issues for the public sector. And at this point, I will hand over to Kirsty to kick off discussing SARS with us.
Yeah, hi. So we've picked SARS as one of the topics to concentrate on because we know that this is something that affects organisations, particularly the public sector. When you are dealing with SARS and FOIs, you have to sort of balance everything, and it can get quite complicated. So again, it's a case of stripping it back to basics. So when you receive a letter which has numerous requests within, it's dealing with FOI, EIR and SARS, just go back to your ROPA. You should all by now have a record of processing activity which details what data you have and why you are processing it. So where you have that should be your sort of key Bible to go back to refer to. And then you need processes in place, you need a system, and you need templates. That they are going to help you enormously. So the processes, you need to ensure that all of your staff can recognise a SAR. So they should, if something comes through on social media and it's a request and someone's asking for their personal data, all the staff need to be able to recognise that that is actually a SAR. If someone calls up and says, I want to know why you're processing this about me, again, that may amount to a SAR. They can be made verbally, so all staff need to be able to recognise that and to know who to refer it to. If you receive an FOI request or an EIR request, frequently we see those that are actually relating to the owner's property or the owner's personal information. So when you have that, it's a case of separating it out. You may want to, if it's easy enough that it's solely their information, then you can deal with it as a SAR. You should just respond to them and say, we're not dealing with this under the FOI or the EIR, we are addressing this as a SAR, and then just automatically deal with it, and just bear in mind that the clock starts ticking. Slightly different timings, but effectively the same. It's a month for SARS and 20 working days for FOI and EIR. You no doubt are fully aware of that. So processes, the public sector are quite good with their processes, so hopefully you have all those in place. Oh, I think you've clicked on to the next slide. Back one more, please. Natalie? That's it. Sorry. Yeah, sorry, I was blathering on about subject access requests, so I'm not surprised if Natalie thought I needed to move on. But basically the system is your next sort of protocol. So hopefully your systems are centralized for records purposes, so you can access the data that's requested. And as I mentioned, hopefully you have your template letters to respond to the subject access requests to make sure they're consistent and to ensure that you are properly applying any exemptions or exceptions for EIR, and the supplemental information that you're also required to supply to the requester. If you have a privacy notice, which I expect that all in the public sector would now have privacy notice in place, that you will be able to attach that to supply some of that information. So each team within your sector, within your organisation, should have a, well, ideally, if you've got a person, one point of call in each department that can refer to issues, if they can identify issues. So each department has an individual to go to, and then that individual can flag it up the chain to the relevant person. But I'll touch on that a little bit later. So what is the right of access? And now we can go to the next slide, please, Natalie. So the right of access is a fundamental right, and you can see that it's been established for quite some time. Again, I'm aware that you're lawyers, so I know you probably know all this already, so I don't intend to bang on about it, but I'm sure you are aware that nobody took any sort of notice of subject access requests until the more recent legislation. When the GDPR originally came in 2018, all of a sudden the public were aware that they had this subject access request right, and organisations had to get pretty up to speed with it quite quickly. Even though it had been around for a long time, no one really used it. So when you are responding to a subject access request, I touched upon before, don't forget the supplementary information. And if you have a privacy notice, you can simply attach a copy of that. So it's all about preparation. You need all your sort of ducks in order to make sure you have everything ready to respond to subject access requests. And your systems and your procedures and your templates are key to that. So you'll see on the screen where the current law is found, and the law is now the UK GDPR, as Kate said earlier. So that changed in 2021 following Brexit. Again, I'm sure you're aware of that. And in the box there on the screen, it confirms what data, what information the individuals are entitled to. So it's different from FOI and EIR. They're not entitled to reams and reams of paper. They're entitled to their information, and if their information is formed within documents or within emails, then yes, you can supply that, but you need to apply the exemptions where possible so you can redact documents. So I'll move to the next slide. So a request for clarification is not to reduce or narrow the request. You must ensure that you avoid that wording. That the person is entitled to their information, so you shouldn't ask them to narrow it. But if you process a large amount of data about an individual and their request is unclear, it's perfectly reasonable for you to seek clarification. If they just say, I want everything you process about me, and you process all sorts that you think that's not really what they're looking for, you may just seek to clarify what they're seeking. So a large volume of data is not defined, and it should be assessed relative to the size of your organisation and your resources. Make the clarification request as soon as possible. And if you cannot make it promptly, document why not. The key is to meet the accountability principle. Keep a note of everything that you do and why, because if you are later challenged, then you have that there and you are meeting your requirements under the accountability principle. Where you need to clarify the identification of a requester, make the request for ID or evidence of third-party authorization if you have somebody making an application on behalf of another. Make it at the same time, make it as soon as possible. So the clock only stops when you seek clarification about the information requested. So it doesn't apply if you ask for clarification, for example, regarding the format of the response. And you'll see from the slide that if the individual refuses to provide any further information, you must still undertake a reasonable search. So the next slide is extending the deadline. And you can extend by up to 2 months if complex, or if several requests are made at the same time by the same person. So if they put in an FOI, a SAR, and a right to be forgotten and a deletion request, that may make it complex. If you need to seek legal advice, that may also make it complex. But if there's something that you standards or seek external legal advice, then that may not be. So again, you have to justify it. So you don't ever request to extend the deadline. It's not a request, it's your decision. You make that decision. If you decide that it is complex and you can justify it and you've recorded how you're justifying it, then write to them to confirm that you're extending the deadline. Again, a template letter is what you need for that. It's case specific. You mustn't do this sort of on every matter. It has to be taken into account the particular request and the specific circumstances of your organisation. If you're a large organisation with a huge legal department and frequently deal with these matters, you may be less able to justify it than if you're a smaller organisation, you just don't have those resources. So the ICO provides examples where there are technical difficulties relating to retrieving the data, and if you need to review large volumes of particularly sensitive information in order to respond, or you have unstructured manual records, which I'm aware, having previously worked in a local council as a data protection officer, I know that there are a lot of unstructured manual records. Or if you need to obtain that specialist legal advice, then that may be justification as to why you can extend the deadline. But that's not justification for not having all your processes and procedures in place and all your documents accessible. So again, justification, you've got to be able to justify it. And so I'll pass it over to Kate to give you a good rule of thumb.
Thank you. Counting again. I'm just going to say that if anyone sees me get up and wave at some point, it's because I'm sitting in a room where the lights have just gone out, which happens to me quite a lot during these sort of things. In a dark room, often people think it's somewhere that they can come into. So at some point I will sort that out, but I can tell you can still see me. So once you have set your deadline, obtained hopefully any clarification that you have sought, a good rule of thumb for commencing your searches for personal data is to consider what searches you would make if you wish to locate the data for your own purposes as an organisation and apply a similar level of effort. If I could go to the next slide, please. The ICO gives the guidance that an organisation should perform a reasonable search. which isn't overly helpful. But what it means is that it is a search proportionate to the importance of providing access to the information and mindful of the resources available to that organisation, which Kirsty touched on earlier in terms of proving that a request is complex. So in essence, you are not looking to perform any searches which would be disproportionate or unreasonable. Oh, my word, lights have just come back on again. The burden of proof is on the controller to demonstrate that the search they have performed is reasonable. And if you receive a SAR where the individual has mentioned certain specific parameters that they would like you to apply, but also some which are disproportionate and unreasonable, you can't refuse the SAR on a blanket basis. You do need to respond to those which are sufficiently targeted and which are reasonable for you to perform. This does mean that you'll have to look at your archives and backups if they are likely to be materially different from the live systems that you have for any reason. But we often have questions about what to do with deleted material. And the answer to that is that something is deemed deleted if you have attempted to discard it, you've got no intention of ever accessing it again, even though it would be available to you with some sort of technical intervention. And that means that deleted items in your Outlook file that haven't been fully purged can still be, are still required to be part of the search. So we generally advise that you look at the systems that you operate, which are likely to process an individual's personal data, whether or not they are emails, SharePoint, instant messaging platforms, and you set reasonable parameters such as timescales. You think of the individuals who might have corresponded about that person, and you do what you can to tailor a response that is likely to give rise to the information that you are aware that individual is looking for. If I could move on, please. Thank you. So once you have, something I should have mentioned on the last slide, I talked about not applying a blanket approach. What you will find is if that you are not successful in receiving any particular clarification from somebody who's made a very wide request, that doesn't mean that you can refuse to deal with it at all. You need to set your own reasonable search parameters and document for accountability purposes that you consider them reasonable and why. But once you've done that, you will end up with information that will generally fall into three pools or balls going into a funnel in this case, which looks a bit chemical. You will have information about the requester, which is linked to or contains personal information that identifies other individuals, or what we call third-party personal data. You will have non-personal data, information about the organization that you're working within, and you will have personal data which is exempt for one of the reasons set out in Schedules 2, 3 or 4 of the Data Protection Act. So you will need to sift through those, which is generally and unfortunately a very manual process, and consider in each case whether or not you can redact certain information. For example, can you simply take somebody's name out of an email where they're mentioned alongside the requester, or is that sufficient? Could they be otherwise identified from the context of the conversation that's taking place in that email? Would you actually be in a better position to withhold the email on the basis of protecting the information of that third party? Or in the case of non-personal data, is it commercially sensitive? Is it something that you simply don't want the requester to see for entirely valid reasons? Or does it really matter? Would it be better from the perspective of appearing to be open in your response to the SAR if it's company, organisation level information that is of no harm to disclose when it's present within a record? Then you might choose to do so anyway. If we could move on, please. Thank you. Looking at third-party personal data in particular, because there is very, very rarely a request where the records don't involve this. The clearest basis as whether you would disclose this information or not is consent. So the steps you would take, you would identify personal data relating to third parties within your records, and you would establish whether or not you have or could obtain consent from that third party to disclose their personal data. If you don't, you then need to consider whether it's reasonable to disclose that third party personal data without their consent. The authority for that is found in paragraph 16 of Schedule 2 of the Data Protection Act. And the consent that you would need from the individual must be to Article 7 UK GDPR standards. So it must be freely and affirmatively given, it must be fully informed, etc. And you might find that it's not always appropriate to ask for consent. There might be quite prosaic reasons in that it's a member of staff has left your organisation and you can't contact them anymore. Or the request that's been received might be quite sensitive in nature. And if you're going to be asking someone if they're happy for their information to be disclosed to the requester, that you're actually disclosing to that third party something quite sensitive about the requester themselves. Or it might simply be quite upsetting or otherwise detrimental to the third party to know about the SAR. A good example of this sort of situation is where you've had some sort of employment issue, perhaps a grievance or disciplinary investigation, and you are looking at whether or not you can disclose witness statements from other individuals, from colleagues to the requester in response to the SAR. And you would need to consider whether or not the information in those statements was given with any expectation that they would be disclosed, whether or not they would be disclosable anyway in the event that employment tribunal took place and you'd have to submit disclosure further down the line, and the nature of information about that third party that is present in the witness statement. And on the next slide, we'll consider this a little bit further. So paragraph 16 again, Schedule 2 Data Protection Act gives specific parameters to help you assess whether disclosure is reasonable without third-party consent. So you're looking at, as the example I just discussed, the type of information that will be disclosed, any duty of confidentiality owed to the other individual, any steps taken with a view to obtaining their consent, whether they have capacity, which may or may not arise in a staff context, more likely a service user context, or whether there's been any express refusal of consent already, in which case you simply would not want to go against that. And other things you would consider is whether it's something that the requester already knows about, so they would be expecting to see it anyway, and if you don't disclose it, then you are not appearing open in the way you're dealing with them. Is it publicly available? Going back to whether or not searches are proportionate and reasonable, how important is that information to the requester in terms of whatever rights they might be looking to exercise alongside requesting their information, because it will have been done for a reason. And very importantly, how disclosure might impact the other individual. If we could move on, please. A very relevant point, which you are likely to already be aware of, but given the audience, Where you are dealing with personal data of health workers, social workers, or education workers in the context of a SAR, there is an assumption of reasonableness in paragraph 17, schedule 2 of the DPA, that provided that their personal data has been processed, collected in their involvement in providing relevant services to the requester, that it is reasonable to disclose information that would identify those particular workers. There's a test for each sector set out in paragraph 17, but each test basically covers that principle. And moving on, please. I will hand over to Kirsty for a lesson in a common sense approach to exemptions.
Thank you. Yeah, so this slide is just to remind you to take particular care when considering exemptions. So health data that's not already known to the individual should not be disclosed without first obtaining an opinion from a health professional. This is to confirm the serious harm test. That's to confirm that's not met, that person isn't at risk of finding out some information about them that they weren't previously aware of. Now, this is an issue frequently faced by the health sector, but there are no doubt many of you which will come across that in your everyday lives. So it's to be aware of that and obviously seek legal advice if you get a particularly technical one that you've just not come across before. So in addition, health data is subject to the usual rules of third-party data and standard exemptions, as well as some additional exemptions applicable if there is a court processing health data, for example, medical reports prepared for proceedings, and if disclosure would go against an individual's wishes. So consider if you're dealing with requests made on the individual's behalf under a power of attorney, for example. And as Kate said, it's normally reasonable to disclose the identity of a health professional who's been involved in giving care. So looking at the next slide, which details the exemptions, there's several up there for you to consider. Not all of them will be applicable to every one of you. But Schedule 3, Part 2 of the DPA contains more detail on health data exemptions, and the ICO, of course, is a wealth of information as well. So the ones that we've identified you're most likely to come across in the public sector are legal professional privilege. So that applies if documents are subject to litigation privilege or legal advice privilege. Confidentiality of references, so this applies to references given in confidence concerning education, training or employment. So if there's any HR staff out there that come across this, or you have staff coming to you for this sort of advice, you need to consider if disclosure is requested by an actual or a potential employee, and it applies to both the giver and the recipient of the reference. So they're the ones that you're most likely to come across. You'll see there are several. It's difficult to pick out one that will particularly relate to any. I'm sorry, I was just looking across to see if there's any questions, but there's several that will affect different sets of you. I've had an inquiry regarding the copy of the slides, and yes, you will all receive a copy of the slides at the end of this webinar. So the next slide, we are looking at the likelihood of prejudice when relying upon these 3 particular exemptions. So I'd expect you may receive exemptions under crime and taxation, which if you receive a request through from the police or the HMRC, you have to consider the likelihood of prejudice when relying upon these exemptions. So for management forecast, you'll see on the screen there, it applies if disclosure would likely prejudice the conduct of your management planning or forecasting. So if you're considering a redundancy scheme, you're looking at a review of your services, then you receive a request for information that may be that you have a relevant exemption to apply there. Again, just remember, justify it, record your decisions, because if you're challenged and you haven't considered it, you haven't got it written down, then that's when you may face difficulties. And again, you're meeting the accountability principle by justifying everything, keeping it in writing and recording it so you have it there. And again, negotiations. So negotiations on your screen. So it applies if it would likely, disclosure would likely to prejudice those negotiations. And again, you have to be able to justify it. So, and you'll see from the note, you have to assess the likelihood of prejudice at the time of the disclosure. So you can't sort of like look back or look forward. You have to deal with it at that time, at the time of the request. So preparing and sending the response. Redactions, you no doubt will have experience of redactions. Sometimes we come across areas at times when this is passed to perhaps a too junior member of staff, which the initial redactions may be able to be made, but obviously that it needs to be overseen by someone who understands what they're redacting. So it's not just names, it's also indirectly identifiable information. So you also need to ensure that redactions are permanently obscured, so you are not able to see through and read the data. That has happened a lot in the past. So you can extract the relevant information from large or unwieldy documents to provide that relevant section rather than providing them with 50 pages of black documents. And you should avoid duplicate copies of information wherever possible. So where you have like email trails, it can get really confusing when there's just like trails and trails. So if you have that trail, try to go to the next one and double check that includes all the others, so you're not sort of sending out reams and reams of paper, which is unnecessary. They recommend that you try to organise the documents logically. This will help the recipient, and it's good practice that's recommended by the ICO. Your response should outline the details of the response, and if you have refused the request, it should state why it's refused, and you should include details of the exemption applied, unless, of course, this would then identify an exemption which would not make it, which would prejudice the purpose. So if you have if you have refused to respond to a SAR, detail the exemption and just make sure it makes sense. If you have refused something and you, by confirming that exemption, it will basically just confirm what they've requested and thereby provide personal information of a third party, for example, which by simply responding to and confirming you've applied that exemption because of personal data, third party personal data, that therefore discloses that you do have it, then you may be able to avoid referencing that. That does get very complicated, as you can tell by me getting tongue-tied by it. So if it's something you don't come across all the time, it's most likely something where you do need to seek some further legal advice. If you are refusing to respond to a request that's manifestly excessive or manifestly unfounded, clearly explain your reasons. Again, justify, just keep your notes. Remember, I think I touched on it earlier, the right is to access personal data. It's not a right to get loads of copies of documents that doesn't relate to their personal data, although you do have to be mindful that if they're requesting details about a property, certainly if it's their property, then that is going to be their personal data. And you can see how that then impacts upon EIR regulations, potentially FOI, and then the subject access requirements for dealing with their personal data. So it can get really complicated. And talking of which, I'm going to pass that over to Kate nicely to deal with dealing with some difficult issues.
Thank you very much. Could I have the next slide, please? You might find that you get a difficult request for various reasons. It could be because it is for a lot of information. It could be because it's part of several potentially overlapping requests, or that there are particularly heavy on exempt personal data. Or you could find that you've got somebody who is simply being difficult, either in general or is using to weaponize their request to place an administrative burden on the organization. So you do have the option to either refuse to respond to or charge a reasonable administrative fee for complying with a request which is manifestly unfounded or manifestly excessive. In reality, there are very, very few people who are charging a fee when you can simply refuse to respond to the request. Manifestly means that the request must be clearly and obviously unfounded and excessive. So you really need to be proving that an individual has no actual desire to exercise their data subject rights. And we'll move on shortly, not now, in a couple of minutes, to discuss sort of examples of when you might be able to prove that. You do need to consider each request on its own merits. If you were to receive several in from one particular request, for one particular requester, but only one of them really meets the manifestly unfounded or excessive threshold, and they are requests for various requests for actual different types and categories of information, you could only refuse the request that is clearly and obviously unfounded or excessive. And as usual, the burden of proof is on the controller, and you therefore, for accountability purposes and to defend yourself in the case of a difficult individual who has gone straight to the ICO to complain that you haven't handled their SAR appropriately and that you're withholding data, you want to document your reasons for refusing the request. So moving on. I've put a link to the ICO guidance, which is our current authority on when a request is manifestly unfounded, and that is pretty helpful. Key points or key indicators are, as I said on the previous slide, no clearly no intention to actually exercise their right of access, which might be shown by an offer to withdraw the request in return of some sort of benefit, or if it's quite clear that the request is malicious and being used for disruptive or harassment purposes. So examples in the ICO guidance that I've picked out are if you've helpfully got an explicit statement of intent to cause disruption, which doesn't often happen, unfortunately. If there is either a pre-existing grudge against certain individuals who are either handling the request or have been named in it as individuals who might have corresponded about the requester. Obviously, you've potentially got the third-party personal data exemption there, but there might have been a pre-existing grudge, or a grudge might be indicated from the context of the request and the people who are referred to in it. Or you could have a systematic targeted campaign, which might, I've seen that embodied by SARs happening for the same type of information, one after the other. So you've responded to one within the deadline, and then you get a request for exactly the same data going forward up to another point. Or it could be part of a campaign of general disruptive correspondence, not necessarily other data subject rights requests. But there is a glimmer of hope, as the next slide will tell, when the DPDI bill comes into force. If I could move on to the next slide, please, Natalie. Oh, whoops, sorry. That was, we've got manifestly excessive first. Please ignore me. I'll hold that bone for later. When a request is manifestly excessive is also set out in the guidance that the link to was on the previous slide. Again, you're looking at clearly and obviously unreasonable, taking into account all of the circumstances, and we have a helpful list of things that you should assess whether you're trying to establish whether a request is clearly and obviously unreasonable. Just reading through the list there to make sure that I haven't missed anything. If you have several requests, but they are for different information and not overlapping, as I've got on the last bullet point there, then it would be difficult to argue that that request is manifestly excessive. You can often simply get particularly disorganized requesters who will issue one request and then think that they've missed something out, and you can have 2 or 3 of the things, all of which are for different sets of information. If there is a small overlap in that sort of situation, then in your discretion, you would probably consider responding to each request, not deeming it manifestly excessive, but obviously taking out any overlap. So in response to one SAR, you cover the overlap with another, but it's very much to be judged on a case-by-case basis. So if I move on to the next slide, please. Then this is what I thought I was going to talk about a few minutes ago. The DPDI bill proposes, and I don't see any reason at the moment why it will not go ahead, an amendment to Article 12 of the UK GDPR and to the relevant provisions of the Data Protection Act to replace manifestly unfounded or excessive with vexatious or excessive. And that will be particularly helpful when you're looking at those malicious requests or something that is intended purely to be disruptive. What you would ideally wish to class as manifestly unfounded, but you might not necessarily be able to at the moment because it's a notoriously high bar to achieve. And the law will contain, once amended, actual examples of when a request might be vexatious. And I've picked out some key ones here. If there is an intent to cause distress, which might just be evident in the circumstances and the nature of the request, not necessarily because you've been told that they are looking to cause distress or pre-existing relationship issues that you're aware of. Not made in good faith. And finally, abuse of process, which is potentially useful, obviously, when there are sort of simultaneous court proceedings, or where they are being used to expedite the provision of information which is otherwise available. And we have a client, a housing association client, who we've been working with quite a lot recently, who receives several pre-action protocol letters in relation to housing disrepair, potential claims for that, alongside which they immediately receive a SAR asking for the identical information, which are being engineered by the particular law firm, of which there are several that are sending these things, to receive the information in support of the potential court proceedings more quickly, because the deadline for disclosure of those is significantly longer than response to a SAR. And under the current law, really, you've still got to deal with both of them. So you've got double the effort, double the legal fees to deal with the SAR as well as the pre-action disclosure. But going forward, it would be handy to be able to rely on that as an abuse of process, vexatious reason for not needing to respond. If I could move on, please. There are various routes available to a dissatisfied data subject. They can and will complain to you. They very often complain to the ICO because it is simple. There's sort of a dynamic online tool for them to do it, and it's free. They can make a legal claim for compensation if they feel they've suffered a loss or material distress because you have, in most cases, failed to, in their eyes, disclose the information that we're looking for. Or if perhaps you're relying on an exemption, or you're relying on a manifestly unfounded or excessive exemption, they can ask a court for an order of specific performance to make you produce the information that they are looking for. Obviously, that's a very time-consuming and expensive thing to do, but it's a potential option. And then outside of the legal route, they can vent their frustrations on social media and try and hit you in terms of reputation. In part 2, we will look at a case where an individual successfully brought an action for misuse of private information, which is something in tort as opposed to a breach of data protection obligations, which was quite interesting. So we'll have a look at that later. Next slide, please. And I've just remembered that I'm actually handing over to Kirsty for this particular one.
Right, so yeah, so I won't go through it in detail, but you may find this slide helpful to keep as an aide-memoire. So, like I say, the slides will all be sent to you following this, and there's an awful lot of information that this topic, as I'm sure you'll all appreciate, is quite technical and quite detailed to go into at sort of your level to get across the nuances and the very technical details of it all. So we'll send you the slides, and yeah, feel free to ask some questions. But we're trying to get through it all in the time allotted. So just on the next slide, we just have some practical tips. So this is things that you come across. I touched on it earlier about the Freedom of Information Act and the EIR. So the Environmental Information Regulations that you may also come across. So there is an exemption if it's personal information. So if it's the person's own personal information, then you just deal with it as a SAR. And I've put there to take a cautious approach where it can make a person identifiable. So if there's something within that refers to, you'll no doubt come across this all the time, where where you get a FOI, for example, to a planning department, and it relates to information concerning neighbours, and it references this person that lives at such and such address, and it's the property that is next door to the pub or something, and there's only one pub in that village and there's only one house adjoined to it, and therefore they are identifiable. So you need to just be aware of that and make sure that that data is adequately redacted. So this is where we come to the details that I was mentioning earlier about when you can exclude it in its entirety. You can then deal with it under the data protection legislation, so respond to it as a SAR, or if there's bits and bobs that are needed to be dealt with under FOI or EIR, but then this personal data element, then you have to sort of sift it through, break down the request, work out under which legislation or regulation you're dealing with, and respond to them separately. We did have a couple of questions in relation to this, and somebody has asked whether I was referring to the neither confirm nor deny in the previous example, and yes, thank you, that is exactly what I was referring to. So that is within section 31 of the FOI, and that gives you the ability to not state specifically which exemption you're applying if it will identify indirectly that person. So if like I gave the example earlier, if someone has said, I want to make this inquiry about Joe Bloggs has done this, blah 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 blah, and the way the request is worded, that by saying that you are excluding the response or applying the exemption of personal data, that in effect confirms that yes, we're processing this data, then you should consider that exemption under the FOI. And so yeah, just take care when information could make a third party identifiable. And there is an exemption for that, but you do have to carefully complete a balance of interest exercise. So if this is something that you're not used to doing, then you'll need to sort of brush up on it before you're faced with it, or seek further advice. Another query was, can you apply the FOI time limit to SARS? No. But it's very, very similar. So it's 20 working days with FOI and EIR, and a month with SARS. So the month takes into account the weekends. FOI is working days, so it's round about the same, but it's not definitively the same. So you need to consider and apply the right time depending on which regulation or law you're applying. So it can get quite complicated. But key thing is strip it back to basics, decide which part of the request needs dealing with under which law, and then deal with it sort of systematically like that. And if you're in doubt, then just seek some advice. So I think we've covered that to death. So I think we can move on to managing a data breach. So this is another key thing that we receive contact from local authorities, from public sector organisations regarding whether it's sort of like school children data, or a breach, in-house breach, a cyber attack. We frequently come across this because obviously you're aware of the time limits that you're under. So a key thing is to know who is responsible in the organisation, and to bang on to your staff that everybody is responsible. It's everyone's role to ensure that they are aware of what amounts to a data breach, what amounts to a near miss, what should be notified to the data protection officer or the information governance officer if they sort of manage data breaches for the DPO. It will depend, no doubt, how large your organisation is, but there should be a go-to person or team. So that message needs to be made clear that if something happens, this is what you do. You don't just ignore it. You don't sit on it for a week. You don't go on holiday and leave it to deal with when you get back, because there's a time limit that you need to adhere to, and that's something to bang on to your staff. I think I touched on earlier about data leads, about having someone in each department who knows what to do. So you'll have your, some of you may be data protection officers on the call, or deal with data protection all the time. But if you are a large organisation and you have numerous departments, it's always really helpful to have that one person in the team that someone can just flag something to and say, oh, I'm not sure about this. So someone with that knowledge. So a lot of organisations will have a data lead or a data champion. It makes sense for that person to be someone in a sort of manager role, so sort of like a relatively senior role for that department, or a team leader. So it's someone that's approachable, that they can just run something by, and then even if the data lead isn't sure, they should be sure that, oh yeah, this is something that needs to go up to the information governance team, the data protection officer, or legal. So it's just sort of like it's having this procedure in place so everything flows, so something doesn't get overlooked. So the data lead or the DPO will be the ones to investigate the breach and to ensure that they understand what's happened, how it's happened, and that they can take any necessary action. You should all have a breach log, or your data protection officer should have a breach log where they detail their breaches and near misses. It's good to record your near misses, because that helps you understand where you're going wrong. You know, can you implement a technical workaround to stop emails being sent in the CC box rather than the BCC box, so it's going to everyone. A easy way to do that is to have some technical way, like a flag, which we have on our emails, flags up and says, you haven't emailed this person before, did you mean to? You have all these people in the CC box, are they meant to be in there? And that's a really, really good tool, and that keeps breaches down. So it will be, ideally, it should be one person. It should be a data protection officer who will manage the situation if you've had a breach, and who will report it to the ICO if it's necessary. They can take measures to then notify affected individuals and any relevant third parties, your insurance company, and ensure it's recorded. So I'll go into that in a little bit more detail now on the data breach slide. Thank you. So reporting timescales. I'm sure you all know you have 72 hours to report a breach. We sometimes come across confusion when an authority has been made aware of the breach. So they are, an email's come in, but it hasn't been sort of received. Again, it's all about justification. It's all down to you to justify something. So there's no black and white. You can't say, well, it came into this department and they sat on it for 7 days because of such and such. You know, that that wouldn't wash. But if there's something that you can justify, it's important to remember that the breach is when it's the point you know or have established that data has been lost or disclosed. So if there's a bit of a flag, you receive an email saying this has happened, you're entitled to investigate that, but be mindful that you have the 72 hours. So if you think, yes, okay, that is a data breach, not sure whether it's reportable or not, but it could be, you're probably better to notify the ICO that you don't, there's a section on the report form as to say we're uncertain, we're still investigating. So yeah, the ICO don't take weekends or bank holidays into account. So the clock starts ticking once you know or have established that data has been lost or disclosed. So if you're able to sufficiently mitigate that risk to the data subject within that 72 hours to make it so there is no longer a risk, then there's no need to report. If there is a risk to the data subject, to their rights and freedoms, then you should put in an initial report within that time period, and then sort of drip feed the information. This is something that the ICO encourages, that you say it's an initial report, more information will follow, this is what we know at the moment, to meet that 72-hour deadline. Equally though, if there's a cyber incident, for example, and there's some forensic investigation that's required, if you suspect, you think, oh goodness, that could have affected all of our files, that could be thousands of people, get your initial report in, but then you have, you're permitted a reasonable time to get to the bottom of the situation. You know, you need to assess what has happened, you need to understand what has happened to be able to advise. If you have to notify the individuals, you don't want to be advising them incorrectly. You don't want to be notifying people and then creating a panic if there's no need to. I would, in that situation, I would try to keep the ICO updated as the investigation progresses. But bear in mind that it is a higher bar to notify the data subject. So you notify the ICO if there is a risk, and hopefully you have a risk assessment that you can complete to help you work out whether there is a risk to the data subject. And if there is a high risk, then that's where you notify the data subject. So if there's certain elements of information that could cause extreme sort of detriment or concern or distress to an individual, then it's more likely that that is a high risk. And if they could do something to reduce that risk, for example, deal with their finance, change their bank details, for example, then it's more likely that you're going to need to notify the individuals. The ICO can be very helpful in that situation, and again, have your procedures ready, have your risk assessment ready. It will make it easier when it happens. So on to the next slide. I've touched on notifying the data subject, so that's if there's a high risk, and the requirement to notify them is without undue delay. But as I said, it's reasonable to establish the position clearly, and I think when I've come across this before, I think it is justifiable that some of these technical investigations that have to take place, if you have to instruct external third parties to interrogate systems to find out what has been accessed, it can take some time. So record it to your risk assessment, detail why it's taking time, detail the steps you're taking, keep the ICO updated, and follow the process, follow your processes that you should have written down to make it run as smoothly as it can. Just be prepared for it, because these things do happen, and we're seeing more and more cyber incidents every day. So be prepared and follow your process. So I've touched before upon template letters. Again, that's something that will help you if you have template letters to deal with a data breach. There's statutory requirements for information that needs to be supplied when you're notifying the data subject. So if you've got your template letter and you have that information in there, that's going to save you time. You're also going to have, no doubt, political repercussions to consider. So just bear that in mind when you're wording the response, especially if you have sort of data subjects that are going to take the matter to the media. Just be mindful and ensure that it is all run through legal, so everything is considered and it is not causing you any undue extra stress when it does. Okay, so hopefully I have covered data breaches. Again, there's a lot more to go through, but in the time we have, I think we've just about covered that. And again, if you do have any questions, stick them in the question box. So I'm going to pass back to Kate to discuss contracts.
Thank you. So the 3 points to cover in terms of contracts, data processing agreements, data sharing agreements, and determining when a party might be a controller or a processor, or perhaps both. Next slide, please. Thank you. So we often get asked what the difference is between a data processing agreement and data sharing agreement, or we find that the term data sharing agreement is used quite widely. So we thought best to address that here. A data processing agreement is a statutory requirement for a controller to have in place with any third party that is processing personal data on behalf of that controller. So Article 28.3 of the UK GDPR says that where a controller is appointing a processor to process data on its behalf, that there must be a written agreement in place, and that written agreement must contain certain contractual rights and obligations which enable the controller to retain control over personal data which is possibly no longer within its own systems or no longer within its possession while the third party is processing it. And those are issues such as the processor can only process the data on the documented instructions of the controller, that their staff need to be under a particular sort of standard and requirement of confidentiality, that transfers outside of the data outside of the UK or onward to another sub-processor are prohibited unless the controller consents or unless the controller has provided a general authorization to anything like that. But you would then expect within the contract there to be normally something like a table that sets out the third parties to whom the processor intends to pass the data for sub-processing purposes, so that consent to those particular third parties is recorded in there, and then a general authorization to appoint others, provided that there are the same controls in place between the processor and the sub-processor as there are between the controller and the processor, or in the case of international transfers, that they are made within the requirements of Articles 46 to 49 of the UK GDPR. I've put waterfall principle on the slide. Article 28.4 of the UK GDPR says that where a processor is appointing a sub-processor, that relationship must be subject to another written agreement which imposes the same or substantially similar obligations as the one between the controller and processor. And you generally find that in a data processing agreement, the clauses are written very much as the provisions of Article 28.3 are drafted, with additional commercial elements such as whether or not the controller will pay for any assistance that the processor has to give if they are cooperating in response to a subject access request, or if they are assisting in managing a data breach. Another very important and required clause to have in there is ensuring that your processor notifies you promptly, usually in any event within 24 hours or something like that, of an actual or suspected data breach. A data sharing agreement is put in place between controllers, which can be independent controllers or joint controllers, and there is no statutory requirement to have that in place. It is something that is best practice. It's generally a document that sets out, like I was talking about at the very beginning of this webinar, how each party will adhere to the data protection principles to ensure that the personal data they process is done in a compliant manner, and particularly documenting what each party's purpose and lawful basis is, and whether or not there are any mutual assistance provisions in place that will enable the parties to help each other out if they're trying to comply with a data subject rights request or similar. So it's an excellent accountability measure, so we would always recommend that you have one. Neither a DPA or a DSA need to be standalone. They can be standalone, or they can be clauses and schedules within wider commercial agreements. We find that public authorities often enter into data sharing agreements or memorandums of understanding or data sharing protocols, I think they're often referred to. So I'm sure that this is something that you have in place, but we just wanted to address some confusion that we often see establishing which is which and which is required and which is best practice. On to the next slide, please. Thank you. I've put a link to some helpful resource from the ICO about how to establish whether or not you are a controller or a processor or both. It's really useful. It contains quite a few checklists. We refer clients to it, and we find it so useful that we actually often use it when we're drafting compliance plans for organizations to enable them to establish within any particular relationship they're looking to enter into who is a controller and who is a processor. And I've picked out 3 key principles that would indicate that you're a controller, which is if you've decided to collect or process the data and you've decided on the scope and purpose of the processing, you're more likely to have a direct relationship with the data subjects, and you are going to have an interest in the outcome of the processing to feed into a particular purpose. It can often be confusing because a processor, if they're performing an outsourced service for you, is going to be paid for the processing of the data, and that's seen as an interest, but it's not an interest that would make them a controller. It's simply they are getting paid for a service to you. They have no actual interest in the detail of the processing that has taken place. And whenever you outsource, whether it's sort of a mailing service or you've outsourced a payroll platform, that will in most cases be a controller to processor exercise, and you would need a data processing agreement for that. On to the next slide, please, Natalie. Some other issues to flag. Sending or storing data outside of the UK is restricted unless it meets the requirements set out in Articles 46 to 49 of the UK GDPR. So if it's sent to an adequate country, which is anywhere in the EEA, or Japan or Canada, if it's sort of certain types of personal data, or if it is sent to an organisation which is registered on the UK, EU and US data privacy framework, which is nice and easily searchable online. If there is no adequacy decision in place for the country that the data is going to be sent to, you will need contractual provisions in place to assist with the security of that data. So for the UK only, it's the International Data Transfer Agreement, or you can use the current EU SCC's standard contractual clauses with the IDTA addendum, if for any reason you're processing the personal data of EU data subjects, which I would imagine to be unlikely. Binding corporate rules will not apply to you, but you might find yourself dealing with large organizations such as Google, for example, who would have them. Or in very rare occasions, you might be able to rely on a specific derogation, such as specific consent of the data subject who would need to know where the data is going to and any risks associated with that. Performance of the contract with them, or you are looking to safeguard the vital interest in a life or death situation of somebody, and for some reason you need to send that personal data outside the UK. Next slide, please. Moving on to case law updates, which I think Kirsty is going to kick off with things from 2023.
Yes, right. Hi, thank you. Just on the next slide, please. So we're going to talk about some case law now. I'm conscious of the time. I've had a message from Natalie that the webinar won't cut off, but we appreciate if you do need to move if you have another appointment. This webinar will be made available on a recording, and we will deal with some questions at the end. And if you have any queries outside of that, our details are on the slides, feel free to contact us. So the London Borough of Islington, this is one of the cases that came through last year. It was under the old Data Protection Act, but it was a claim that was brought by a resident for the misuse of private information, of financial information. The person the council had accessed their financial data, but when dealing with a housing repossession matter for the neighbour, they tried to justify it that it was as part of their sort of public task to manage this, and the court refused that. They disagreed with that. So there was there were damages awarded for the breach of the right to privacy, the court decided that it was disproportionate. The access of that data was disproportionate and amounted to a misuse of the claimant's private information, and 6K was awarded. That was because it was aggravated. That it's an interesting case, and if you're not aware of it, it is worth researching in more detail to see how a similar matter could affect you. So it will be more relevant to some of you than others, but it's an interesting case because the claimant was able to receive damages for the right to privacy without proving material damage. So on the next slide, I have some of the ICO reprimands, and you'll see on there's a few council, the NHS. So if I just outline a couple of them. So as I'm sure you're aware, that the ICO has indicated that they now prefer to deal with public sector issues by way of reprimands and enforcement notices, rather than whacking one department with fines. I think they've decided it's not worth robbing Peter to pay Paul. You know, they're your government agencies effectively, so it doesn't make sense. But that doesn't mean that you should sort of take the foot off the gas with regards to your compliance, because if something serious happens, then I'm sure they will change that view. So the Gloucester City Council matter, that was following a ransomware attack. Like I say, we're seeing more and more of these cyber incidents, and a key recommendation that the ICO made was to ensure that all your staff receive phishing training. They've suggested that you have multi-factor authentication or two-factor authentication, so your devices have, like your laptop, your phone, have that second layer of security that needs to be passed. So it can help prevent external parties gaining access. It's not infallible, I'm sure, but we're seeing more and more of these cyber instances every day. They are becoming more and more clever. They're finding more and more ways to infiltrate systems. No doubt you've recently seen the massive one that's happened at the MOD. You know, that's quite a concern. So every little step organisations can make to protect that data is key, and it's part of the requirements of the data protection legislation to ensure that you have those appropriate technical and security measures in place. The ISO also suggested that the council should determine and communicate security requirements to their suppliers and make sure those are formalised within contracts. We still come across organisations that have contracts with different suppliers, and they don't have any data protection terms in. You know, some of these contracts may have been running for years, but you know, the data protection legislation has been in for years and years. It's just more at the forefront of people's minds now with the 2018 changes. And again, as Kate touched on earlier, there's going to be more changes to legislation, but hopefully that might make it a little bit easier for public sector organisations. So, they also suggested that you have backups of your data. So I would expect that most organisations would have secure backups, but there was obviously an issue in this matter. Just touching on one of the other ones on your screen, the NHS Lanarkshire matter. They shared sensitive patient data within WhatsApp. WhatsApp is not a secure method of sharing data. It shouldn't be used. Everyone started using it for when COVID hit. Everyone started using it then to message the team. I think it's used for that. It's perfect. I'm running late. I'm going to be late in the office. Can you grab me something for lunch? Shall we meet later tonight or something like that? Fine. You know, that's reasonable. Putting patient data on there, big mistake, because then someone managed to add somebody who was external to the organisation, and all of a sudden they had a massive data breach. So they've been recommended to take a data protection by design and default approach before deploying new apps. Like I say, WhatsApp came in across the board. I think everyone started using it with COVID. It was a bit rushed, but now look back at those processes, make sure you've got some sort of social media policy in place to ensure that it's not misused, that people understand the risks behind it. If you are putting in a new technical app, something like that, do a DPIA, you know, risk assess it, make sure that you have mitigated the risks sufficiently. So let's have a look at the next slide. Oh, we're on to this year now. Sorry, we have gone over, but over to Kate to talk about some of the issues this year.
Thank you. Next slide, please. This very recent EU decision, obviously not a UK decision, excuse me while I shamelessly refer to my paper notes now. This is an interesting decision which we strongly suspect for the protection of our adequacy decision from January next year that the UK courts will follow. Endemol Shine Finland, there was determination that oral processing of the data, which is essentially verbal communication of information that was contained in a register of persons, which was determined to be a filing system, within the meaning of Article 4.6 GDPR, which is the same as our UK GDPR, was caught within the material scope of the GDPR. So historically, we have taken the view that processing of personal data is done if it is in writing, if it is done automatically by a computerized system, and anything, whilst if you disclose something verbally, you might end up with a personal data breach on your hands, it wasn't strictly covered by data protection provisions, but it is entirely possible now going forward that we might find that verbal conversations within organisations or even outside of organisations will be captured by the requirements of data protection legislation. Moving on, please. Thank you. So we've got a list here of some reprimands and action from 2024. The West Midlands Police, this was a case of essentially confusing two very similar sounding data subjects, people with very similar personal data, one of which had serious safeguarding concerns relating to them, incorrectly linking them, merging the records so that the police turned up at the door of the unaffected individual. I won't go too much into Dover Harbour Board and Kent Police because we're looking at WhatsApp again, and Kirsty has already made it quite clear that WhatsApp, certainly on personal devices, is simply not appropriate. And to the extent that you're going to allow any personal device use at all, then you would need a very strict bring your own device policy to cover that, and the particular backup requirements, etc., of storing messages and having an absolute right to inspect a personal device so that you are maintaining control of the information within it. Ministry of Defence, that's a classic howler, sending emails in the to field rather than the BCC. And Serco Leisure actually had an enforcement notice issued because they were using facial recognition technology and fingerprint scanning purely as a sort of a clocking system and to monitor employee attendance at their facilities, which is highly intrusive, highly disproportionate for the purpose of determining who is going where and who is turning up on time or late, when that could be done by swipe cards. And it's something that we are seeing quite a few clients coming to us who have already implemented fingerprint recognition technology simply for attendance and entering and exiting a building, which isn't a particularly high security, it's just a run-of-the-mill workplace activity. So there is relatively new guidance that's been issued on what a biometric recognition system is and the compliance requirements of whether or not it can be used and how to assess it. That is on the ICO website. We have, well, I haven't, Kirsty has written an article which she'd be happy to send to you on steps to consider before implementing biometric software, but it is something to be extremely careful of. And moving on, please. And final thing to cover is the main proposed changes that the DPDI bill will likely affect the public sector. And we have, because of the nature of this, actually touched on the first two in a fair bit of detail in part one of this webinar. The main helpful changes to certain definitions is essentially the definition of personal data and when you can identify somebody, and the testing that is going to have to take place around that in terms of whether you reasonably know whether somebody else could get hold of some other information that could identify that individual. So it's on this slide, but there is no further need to talk about that or the vexatious exemption for SARS. Evidently, as public authorities, you have DPOs. Going forward, you will not need DPOs, but what you will need is a senior responsible individual. And that senior responsible individual has exactly the same tasks set out in the legislation as the DPO. So the role effectively doesn't change, but the individual does. It's somebody that needs to be a member of senior management, so essentially on the board. But that individual can delegate their tasks to other individuals who are able to implement them and have expert knowledge. What they can't delegate is their statutory responsibility. I think a key change is that people who currently operate as bolt-on in-house DPOs, those people can still be hired as experts where a senior responsible individual is delegating their tasks, but they cannot act as that senior responsible individual, which for them would probably be something that they would prefer in terms of a responsibility perspective. But that is a fairly important change. And finally, the record of processing activity, which used to apply to any data processing that you do, or currently still does, because the changes haven't happened yet, and which is an enormous unwieldy Excel workbook, usually with tens and tens and tens of tabs in it by department, and is almost impossible to navigate your way through. That is only going to be required to the extent that an organisation carries out high-risk processing, and from that perspective is only limited to the high-risk processing. You don't need to keep it for everything that you do. So that is a positive change that we are going to see incoming. I've seen we've got a question. Does this mean, going back to the Endemol Shine, does this mean that we can no longer confidently rely on Smith versus LGBT Foundation for verbal disclosures? And that's absolutely, well, it will mean that we can no longer rely on it to the extent that a UK court follows the Endemol Shine judgment. So it's there, it's applicable in the EU. We strongly suspect that we will follow suit, but at the point, because the EU ruling is not applicable in the UK, we're still relying on Smith versus LGBT Foundation until it changes, but we strongly suspect it will change. And next slide, please, Natalie, which I think should be the final slide before we release you back into the wild. Thank you very much for your patience and for your questions. We are more than happy to take further questions, but I do appreciate that you will now be extremely tight on time because we have run over. As Kirsty said, you'll receive a copy of the slides. There'll be a link to this webinar on YouTube, and we will also be sending out a survey for feedback after the webinar has finished. But if you have any questions, please do fire away. Otherwise, thank you very much.